All right. Good morning or afternoon, everyone. Welcome to the second webinar in our 2025 Estate Litigation Webinar Series, Undue Influence Over the Vulnerable, Protecting Against and Preventing Coerced Estate Plans. My name is Desmond Mitic. I'm an associate in Calgary's Fasken office, and I've got a broad practice, commercial litigation, arbitration, but I often assist clients with estate litigation matters. Now, before I introduce my co-presenters, Helen and Nicole, I just want to direct your attention to some administrative information that's going to be on the screen, deal with a few housekeeping things. So first and foremost, and because I know we have a national audience today, and Fasken's a national firm, I want to reassure you that the principles we're going to be discussing around undue influence, they're largely consistent across Canadian jurisdictions. So if you're joining from another province or territory that's not Alberta, where I am, or Vancouver, where Nicole and Helen are, the content today is still going to be applicable. And if you need any help navigating local nuances, we've got colleagues all across Canada who can assist. And if at any point during the webinar you require some technical assistance, or if there's some instructions on the screen about how you're going to be able to access that, including how you can turn on closed captioning, if that's something you're interested in. Next, I'll just remind everybody that at the end of the session, we're going to be addressing some questions, and we've received some prior to the session, and we thank you for those. But if anything crops up during the course of the presentation, there's a questions tab available to you in your interface where you can drop in your questions for the speakers. And finally, at the end of the session, there's going to be a link or a QR code that's going to allow you to access continuing professional development credits, or a link to obtain those credits, something like that. So there's also going to be an option for you to download the presentation and the materials, fill out a quick survey. So if you wouldn't mind doing that, we would appreciate it. Now with that, let's move on to some introductions. This morning, I'm joined by Helen Lowe, King's Counsel, partner in our estate litigation practice group, who has a wealth of experience in this area, and Nicole Krige, who also has a wealth of experience. She's practiced in this area both in South Africa and now in Canada. Helen, thanks for coming.
Thanks for that introduction, Desmond. Hi, everybody.
Good morning and good afternoon, everyone. Happy to be here, and thanks for joining us.
All right, to start off, before we dive into the legal framework and then discuss some practical examples, Helen, why don't you tell us a little bit about your career, how you got into this line of work, and how you see these kind of issues cropping up?
Yes, thank you, Desmond. I hate to be sort of a estate litigation geek, but I'm really into my area of practice. I started focusing on estate litigation, pivoting from commercial work, like part of what you currently do, Desmond. And it was very interesting to me because, you know, in the commercial area, everything is about the numbers and the economics. And then I was moving to a different practice area where the law is complex, but even more complex are the dynamics amongst the parties to the dispute. And resolving those is often a real challenge because it is not for these litigants always an economic decision. It's not always a cost benefit analysis. There are so many other emotions and factors that go into the dispute. And often the deceased person was the glue that kept the family together. And then when they age or lose capacity or pass away, then, you know, everything comes undone. In this area, also, it's just burgeoned from the time that I first started because of the demographics. The baby boomers are aging and they have accrued significant wealth because of the good economic times that they enjoyed. And most recently, I read that there is a $2 trillion transfer of wealth over the next 20 years in Canada alone. That number is staggering in the US, and some of our work is affected by that. But how estates and assets and inheritance will pass to the next generation or the next set of friends or charities or causes will certainly raise disputes. And I think that as we live longer, as medicine progresses, the good thing is, I guess, we live longer. One of the side effects of that is as we age, we can become more vulnerable. And even if we don't entirely become, fully incapacitated, an elderly person can lose some of the judgment and the memory that they had that made them better judges of character and such in their earlier days. And what that causes at the end of the day is a lot of people out there who are subject to undue influence, and even more than them are the predators out there who will try to take advantage of that, whether it's just within the family of the individual or strangers to them. So it's a very exciting area, if I could say that. It seems a little macabre.
Thanks, Helen. And I agree. That perspective really puts the nature of growth in this area in the forefront of our minds. And, here in our office, we're certainly seeing an uptick in these type of files. And now, Nicole, what about you? What drew you into estate litigation, and how are you seeing these issues tend to crop up in the cases you're working on?
Thanks, Desmond. Well, as idealistic as it sounds, I pursued a career in law initially because I genuinely wanted to help people. And estate litigation is pretty interesting. It's complex, it's deeply personal, and the consequences can ripple through families for years. It's been a very fulfilling area of law for me because of that. I've seen how undue influence specifically can quietly yet pretty destructively reshape even the most well-intentioned estate plan. And it just leads to heart-wrenching consequences, especially when vulnerable individuals are involved. These disputes are often layered with emotion and history, and suspicious circumstances can crop up more often than you'd expect. It's subtle, but always something that we want to be looking out for.
That's great. Thanks, Nicole. Now, I just want to jump into a little bit of the legal theory here and anchor ourselves in the doctrine of undue influence and a little bit about how the court's going to approach it to frame the rest of the discussion. So the doctrine really, it allows courts to invalidate certain gifts, transactions, wealth transfers, testamentary documents, where one person's free will or their ability to make independent decisions has been influenced by another person, often somebody in a position of power. And it's interesting because our law allows influence, it allows persuasion. Not every influence, not every persuasion is unlawful or rises to the level of an undue influence. So the question becomes, has the influence exerted on the individual risen to a level of coercion such that it destroys or inhibits their free will, which is a complicated assessment. And it gets a little more complicated in that the degree of influence that's required to meet the threshold actually varies depending on the degree of vulnerability of the individual in question. I was reading an article recently that kind of spoke to this point, and I'll quote it here. The author said, "The lower the capacity or the cognitive status of an individual, the less influence would be required to determine that that individual was incapable or unduly influenced. Conversely, if an individual with only mild impairment of cognitive function would have been subjected to a severe level of influence to the point of coercion or containment before that influence would be considered undue." So it's really capacity and vulnerability that set the stage for how much influence is needed to cross the line. And that's only part of the picture. In practice, courts are also going to look at surrounding facts, what are often called suspicious circumstances, because those can also signal whether free will was compromised. And suspicious circumstances, that typically refers to any fact surrounding the preparation or execution of an estate plan that calls into question somebody's capacity and suggests that their free will might have been overborne by acts of fraud or coercion. So once we understand the circumstances, the next question becomes, okay, who carries the burden of proof in one of these disputes? Ordinarily, it's the person who seeks to enforce the transaction or the testamentary document that's got to prove it was duly executed with the knowledge and approval of the individual. Then it's the challenger that bears the burden of proving, well, that was actually executed under undue influence. Except for in extraordinary circumstances where the presumptions can be flipped and something called the presumption of undue influence is triggered. So Nicole, why don't we talk about a little bit about that? Under what circumstances would we flip the ordinary burdens and see a presumption of undue influence being triggered?
Sure. So as you've already mentioned, courts across the common law provinces in Canada tend to treat undue influence and the presumption of undue influence quite consistently. Our law presumes undue influence is present where a relationship of dominance or dependence exists. Certain types of relationships have always been recognized by equity as giving rise to the presumption, such as the relationship of a parent and child, solicitor and client, or guardian and ward. And whether the presumption will arise in other relationships will very much depend on the circumstantial evidence. If the presumption is triggered, the burden then moves, or the burden to prove the absence of undue influence then moves to the person seeking to enforce the gift or the testamentary document.
Thanks, Nicole. And that makes some good sense. And just so everybody's on the same page, to recap, influence itself is lawful. It becomes undue when it overbears somebody's free will. Capacity and vulnerability affect how much influence is required to cross that threshold. Suspicious circumstances can help. The presumption of undue influence arises from relationships of dependence, dominance, or power, and that shifts who's going to have to prove what. So with that foundation in place, let's take it to practice, talk a little bit about why that matters so much in the day-to-day, and see where the doctrine meets real people, family dynamics, and importantly, the evidence. So, Helen, you've been doing this for over 2 decades. You've seen a lot. From your vantage point, how does influence typically surface in practice? What makes these files so interesting and challenging to prosecute?
Yes, well, Desmond, it is noteworthy that when clients come into my office, I'm going to say about 80% of the cases, the person comes in and complains that there has been undue influence. They say, this has happened. I used to be, the preferred child. I used to be an equal child, and now this has happened. My sibling has secured a benefit already. And they come and they say to me, there's been coercion on my parent, and I need to have this stopped. And they say, doesn't the law stop this type of behavior? And when I explain to them the doctrine of undue influence, which you just have in this presentation, they get quite excited, like, yes, this is it. But ultimately, what is very difficult for them to understand is that the doctrine, although when you read it, it seems fairly straightforward and that it would be readily used. The finding of undue influence in the cases, if you read them, are few and far apart. And in part, I think that is because a good undue influencer is going to be subtle about doing that. And so proving the elements of the legal test is often very difficult. It has to be done through circumstantial evidence. And when you look at undue influence, you need to keep a few things in mind. And this is what you need to be aware of. First of all, it is perfectly proper to be able to use your persuasion and your guile to get a benefit from somebody else. So if I want to do nice things or, show you why you should give something to me, that doesn't amount to undue influence. The persuasion needs to cross over the line of overbearing the will. That's the language you used. And and how would that be proved? That's difficult, right? Because often the person who's being influenced is now deceased if you're getting into litigation. And most importantly is most of the time when you ask the vulnerable person, oh, you've made a change to your will, and now instead of leaving it to Nicole, you've now left it all to Desmond. And the vulnerable person is going to say, oh, yes, I did, because Nicole has been really good to me. She's really right, and I heard her speak, and, whatever the person tells you is often very true, but the question is whether they've been able to apply judgment to that wouldn't exist if Nicole wasn't exerting that force. And because undue influence is not, sometimes we talk about it as like kind of the legal gun against the head, but it's not that the person applies the legal gun once. It's like subtle steps, constant, little things that build trust and evidence in favor of the undue influencer, because they're the ones that take the good steps for the individual. They're the helper. They are the ones that support them emotionally and sometimes, physically, health-wise. So ultimately, undue influence is very easily recognized by the client because they know the parent. They go, there is no way my mother would do this before. But the court doesn't know them, and it's very, very difficult to prove.
Thanks, Helen. And I agree. Not only difficult to detect, but even harder to prove because, as you mentioned, the coercion, the assistance, the influence, it's subtle, often hidden. It's difficult to gather evidence and build a case. That brings us to the challenge. And that's why I want to pivot now to some practical examples. Let's go through some scenarios, think about how we might build a case for undue influence or deal with these kind of things as they occur. First scenario, I'll call it the Smith family case. Standard kind of case we see this kind of thing all the time. Obviously anonymized, the subjects to the Smith family. So it goes like this. Mom has died. Dad's been left alone after 50 years of marriage. He needs some care and support because historically his wife had been doing everything for him. He's got 2 children, only one's in the same town, the other in another province. His relationship with the children is good, but it was really Mom who was the glue of the family. There's a widow next door. She's been coming by, helping Dad with meals, providing some companionship. And this relationship's getting closer. She's visiting more often. There's also somebody from a local charity that Mom used to attend who's coming by and suggesting to Dad that, well, when I was speaking to Mom, she mentioned that you two were going to change your wills to give a bigger gift to the charity. So this kind of thing is happening. Helen, what's your take?
Well, these are very, very typical kind of facts. Sometimes you can substitute a different fact in, but quite often you have a situation where you have some level of vulnerability. And then the question is there somebody who comes into that situation where you have the vulnerable individual who can create a relationship that then creates some sort of power by the influencer over the vulnerable person. And in these circumstances, whether it's, if the influence has happened yet or not, it's sort of important for family members to recognize the possibility of that before it happens. It's much easier to prevent undue influence and a change in an estate plan before it happens, before a document is signed, than afterwards by, hundreds of degrees, really. So, what are the red flags arising in this scenario? I'm sure most of the online audience has already thought of their own. But first of all, let me go through a few. There should be warning signs, to the family and the loved ones of the vulnerable person. First of all, recent bereavement and emotional vulnerability. What that does is it makes the individual, particularly if it's overlaid with age or physical frailty, all of that recent, illness, all of that makes the person very susceptible to a lower level of influence than what they might ordinarily need to be subjected to have their will overborne. So that is one warning sign or red flag. Another is where the individual later in life develops new personal relationships. Some of those can be benign. Maybe the widow next door, is lonely. Maybe she wants to have a spouse. It's not clear, but once somebody new comes into the individual's life, that's a person who could be a potential influencer. Another kind of red flag that didn't exist before mom's death is you had two children, one lives here, one lives out of province. That usually was not much of a problem, but that type of geographical separation that by its nature results in a different level of contact necessarily between the family members, that can give rise to perceptions by the vulnerable person that one person is helping and one isn't, and one is a good child, one is a bad child, separate and apart from all of that, it also, for all good children, it makes it all difficult to oversee your parents if you're not in town in terms of what is happening in their lives. And finally, another third flag is that there can be third parties who have interests that can, in effect, influence the vulnerable person to do something that they don't intend to do. It's not as direct necessarily as give me money. So we put in that charity canvasser to show you that an individual can be persuaded to do something else. So a friend of the child who lives close to the parent might influence the parent to prefer Nicole because Nicole lives in town and Desmond does not, for example. So the type of influence and how it can be applied, there are many different ways in which benefits can be conferred, and sometimes no benefit, but the influencer is just really a rogue person causing, mayhem. So all of that is something one could be alert to at the time, and if there's a concern, then you need to go to the next step.
Thanks, Helen. And that's why I like this scenario, this fact pattern so much. When I was first thinking about putting this presentation together, this one seemed a bit vanilla. Like you said, this is almost the base case, but I think it illustrates some important concepts that go back to what you said before about almost 80% of the files that come into your door have some element of undue influence in them. This fact pattern, this scenario kind of demonstrates that. It's a relatively ordinary course situation. Dad's getting older, mom has died, they're vulnerable, people are coming around to help them. It's in these benign type scenarios that we can see or we need to be on guard against these kind of influences that could occur. So thanks for that. Let's move to another scenario. A little bit of a different dynamic here, but just as legally significant. Often people that are in the best position to spot influence, to spot coercion at an early stage, maybe before it becomes a problem, are professionals like advisors, bankers, sometimes lawyers. So Nicole, I want you to consider this one. You're a financial advisor. You've got a long-standing relationship with the client. Lately, they start bringing somebody else along to meetings. Maybe it's a family member, maybe it's a friend. You notice this person speaking over the client, maybe interjecting, answering questions on behalf of the client, pushing for changes to the client's financial plan. You're a little bit worried about coercion, that they're being influenced. What should you do?
This situation, it raises concerns about the client's autonomy and whether their financial decisions are truly voluntary. And when someone begins speaking over a client or answering for them and pushing for changes, it's certainly a red flag for potential undue influence. If you do suspect that coercion may be at play, I highly advise you to document your concerns. Record what you're observing in detail. Who said what? How did the client respond? Have there been any changes in tone or decision making? Does your client appear afraid of this family member? Does the family member speak harshly to your client? What is the dynamic that you're observing between the two? Note that. These will be behaviors you want to record as you're observing them happening. Another thing to do is make sure you're obtaining instructions from your client privately. Request a one-on-one meeting to confirm your client's wishes without the external pressure. You may also want to assess capacity and voluntariness. Now, these professionals aren't expected to conduct an assessment with legal or medical precision, but there are certain questions that you can ask yourself. Is your client appearing confused, hesitant, or are they deferring excessively to this family member or friend? Note those things. And if that is happening, you may want to pause the transaction. Seek advice from your supervisor or your legal department or your compliance department, and certainly advise your client, if that is happening, to get external legal counsel, independent legal counsel. But this family friend has taken me to his lawyer and they've explained it all to me. He needs to get his own lawyer and ensure that his interests are being protected. Document everything, obtain instructions privately, try as best as possible to assess the voluntariness and capacity, encourage your client to seek independent advice, pause the transaction if necessary, and report your concerns internally where you are finding that the red flags are stacking up.
Thanks, Nicole. And that makes good sense. And I think it gives me a moment of pause and to remember, as a professional, we kind of always have to be on guard about avoiding participation in any transaction that might appear coerced, that might appear like influence was at play. And we got to remain mindful of our own exposure to liability if those red flags are present and they're being ignored. Because remember, if you're involved in a transaction, and if you're involved in a plan, if you're involved in something, and the case later goes to a court dispute about, someone was unduly influenced, your role in that transaction could come under court scrutiny. So with that, let's go to the next hypothetical scenario 3. We're going to imagine a person, Jane. They're 85. They live alone. They've been diagnosed with mild dementia. Still competent, but, the inklings of dementia are beginning. Jane's daughter lives 2 hours away and has arranged for a caregiver to meet her 3 times a week to check in, make sure she has groceries, make sure she's taking medication, gets adequate exercise, the usual stuff. Jane phones her daughter one day and says, "I've seen a lawyer. I can't remember who it was or why I went." What should we do in this situation? Helen?
Well, I think first of all, you probably have to calm down Jane's daughter. But once she understands that there is something that can be done, then we can talk to her about those steps. And importantly, I think the first thing she needs to determine is, does she need her own lawyer? Or does her mother need her own lawyer? Or do both of them need their own lawyer? Because first of all, Jane should get clarity on mom's mental status. And the reason for that is if mom is unable to manage her financial and legal affairs, then she needs a person who legally has the authority to act on her behalf to investigate and potentially undo whatever transaction occurred. But if mom's mental status shows that she still has mental capacity, then the question is, can mom give, and does mom want to give her daughter a power of attorney, a private authority conferral, which is important so that Jane's daughter can go and help her mother and figure out what has gone on. So the first thing is, does it require a guardianship committeeship order because mom is incapable now, which potentially affects the ability to set aside what mom might have inadvertently done? Or can mom confer that authority to Jane, to her own daughter, to do that? Once you have the power of attorney or the court order in place, then you can have authority to go and represent mom, to try to find where mom went, check on her financial records to see if she may have paid a lawyer, try to investigate that. Or if you don't know that, otherwise it's a wild goose chase, right? If you live in a big urban area, how are you going to know where mom went when she doesn't recall? Which, of course, itself is a very, very suspicious sign. But she might have enough capacity to go and revoke something that she has done. So she could do that by making a new will that is consistent with the one that she had before. So that if she made an intervening will that was the product of somebody's undue influence, that would be revoked by her latter action, assuming that she still had authority. If she doesn't have authority, through the court order and the medical reports, it's probably fairly easy to be able to set aside what she did without memory based on just lack of capacity. And you don't necessarily need to determine undue influence. The investigation you do want to do is, who is this person? Someone had to drive her, right, to the lawyer's office. And that person may be benign, but maybe not. Maybe she drove her to a lawyer's office and nothing happened there. But then you know that there's somebody else up in her life. And that's something that you have to keep tabs on, I guess, going forward. And the final thing I would say is Jane's daughter should just document everything. When it's happening, it's so fresh in your mind, you don't think you can forget it. But over time, memories and timing, it all fades, and keeping detailed records of what Jane was telling her, what she did, what other people were saying to her, that might all be critical if there's a legal actual challenge or court case in the future.
Thanks, Helen. That makes a lot of sense. And before we move on to the next portion here, let's do one more of these scenarios, because this is something we see come up all the time. In this scenario, we've got two business partners, Ben and Jerry. Ben is Jerry's son and trusted business partner for the last 30 years. Jerry's getting older, and he's appointed Ben as his attorney under a power of attorney and as executor of his will. Now that Jerry is 88, getting close to 90, he's frail, he's being cared for by his daughter, Kate. Kate's begun isolating Jerry, controlling access to the house, intercepting Ben when he visits, isolating him. Out of the blue, recently, Ben receives a written notice. Jeremy's revoked the power of attorney and signed a new one. Nicole, what should Ben be thinking? What should Ben be doing?
So, frailty doesn't mean lack of capacity. It's just getting old. So mere frailty and even mild dementia does not mean that Jerry lacked capacity when executing the new power of attorney. Even with the diagnosis of dementia, capacity fluctuates. So the new power of attorney is only going to be challengeable if it can be shown it was signed during a period of cognitive vulnerability or under pressure. And because coercion is often subtle and is usually the result of a drawn-out effort to wear the person down, it is vitally important to document red flags and as and when they arise. So in Ben's situation, I would advise that he maintain a journal of dates and details of all his attempted visits to his father. I had a client who was being isolated from his father to the point where his siblings had actually installed the doorbell cam at the father's home, which they could control. So every time they saw he would arrive, they would run down the street and intercept the visit. That was how calculated the coercion was. So you want to keep a journal of these things because ultimately, when you're preparing for trial, it's only when you see that chronology of events that took place over years can you see the pattern that arises. You also want to document the dependency and control. Just to what level is Kate involved? How dependent has Dad become on her? You want to document that. Retain all communications and discussions you've had with Kate. Keep record of any changes in Jerry's behavior or statements. And if Ben does start suspecting that his father has diminished capacity, take him to a medical doctor for a cognitive assessment and to an independent estate lawyer for a legal capacity assessment, because these two assessments are not the same. A medical diagnosis is only indicative, but not determine, it doesn't determine a lack of capacity or vulnerability. Well, it indicates vulnerability. Demand a copy of the new POA so you can determine who was involved in its execution. Try unravel, like, how did this even come about? Start doing some investigating and keep close to the father as much as you can, despite the efforts of isolation. And finally, you want to seek legal advice, because if you let this go on for too long, sometimes it's just irreversible, the damage that it can cause. So you want to get in early. You want to figure out what's gone on. Does he even understand that he created this new document? What was the reasons for it? Is this truly what he wants? And you could take it from there.
Appreciate that. Thanks, Nicole. And what I like about all these scenarios and what I hope is coming across is the point we're really trying to drive home here is these situations can be complex. They deal with private relationships, and trying to prove that any of this occurred after the fact is going to be incredibly difficult. That's why a lot of the guidance here is document things, relying on circumstantial evidence later or conjecture can make the case a lot more difficult. Prevention is the key. So let's turn to the next slide, speak specifically about what professionals, families can do early on when these kind of things start happening to reduce risk and protect vulnerable individuals, maybe avoid disputes down the road. Helen, have you seen any situations where early involvement has helped prevent a dispute that might have otherwise escalated?
Yes, actually, we do actually have clients who come to us sometimes before they know that anything untoward has actually taken place in terms of a legal plan, a estate plan, or a perfected gift. And they say, something doesn't seem right. What my parent is telling me suggests to me that, I think my sibling is, on uh, a warpath to get me looking like the bad guy. And that I think is going to lead to me being disinherited in the will. And quite often people get, I don't know, I guess the word is very upset about it. And therefore they kind of back off, like, look at my mother saying this about me. Why should I go and see her? And I always suggest the opposite. I always say, if you think something is happening, notwithstanding your mother might be saying things about you that are untrue, go and visit her and calmly and, with kindness, tell her why she's wrong. Don't step out of the situation, because if you do, it opens the playground for influence to have a bigger playing field, really. You want to be in there to stop any factual allegations that are not true. You want to continue to provide the care that you would and the contact with your parent, because ultimately you do want them to be able to go and secure perhaps their own independent legal advice and hear somebody who will question. If they go and make a will, all of a sudden, between Nicole and I, all of a sudden everything comes to me and not to Nicole, as was in wills that have been made since we were kids, then you want that person to, you want the vulnerable person to go to a good and knowledgeable lawyer who would question that and document that. The other thing also is that often, if I'm the undue influencing child, Nicole probably doesn't like me very much. And she doesn't want to have much contact with me because obviously, that relationship is very, very strained. But I usually advise Nicole, no, keep close to the undue influencer and not just the vulnerable person, because you want to know. Nicole should hear what I'm doing and my justifications. And as she said, document this stuff, because all of that might add into the milieu of facts that go into proving undue influence, which we already said is very subtle, very circumstantial. And so, as we know, if you're drawing on circumstantial facts, the more that you have, the better it is. So, sort of in the words of, Sandberg, lean in. It's a slightly different meaning, but it isn't. Participate, into the lives of these people. Both the vulnerable, the undue influencer, the support network, and quite often, especially if it's a stranger, they'll go for a different mark, right? They're trying to get more easy prey. And if you make life really difficult for them because of the oversight, they might leave your parent alone.
Thanks, Helen. And, your reference to lean in reminds me of another phrase, maybe a more cynical one: keep your friends close and enemies closer.
Yes.
Nicole, what about you? Any sage advice for the audience if somebody's worried about undue influence occurring in an estate plan at an early stage?
Well, as a litigator, I can't say it or stress it enough, is document everything, because we want all the evidence. We need all the evidence we can get, because it's such a, it's something that all that circumstantial evidence needs to be relied on to show the grand picture. So if you're a family member, an advisor, a professional, the best way to protect the estate plan from undue influence is to ensure that the donor or the will maker's intentions are clearly recorded. ideally through contemporaneous notes, capacity assessments, and independent legal advice. If you're, he's made a new will, but then tomorrow he phones you up and says, oh, well, this is what I want. You keep record of those contradictions. It's going to paint the picture that, not everything is sunshine and roses, and he might be faltering in their intention. Keep record of the circumstances, the suspicious circumstances, the changes in behavior, the symptoms of possible cognitive decline. If there's any concern about vulnerability or coercion, don't wait and raise the issue early. One of the tools that is available to people is that if this is happening, you can report it to the public guardian and trustee. They might not be able to do much, but it does create a paper trail, and they may actually provide some good guidance too. And where there's isolation and maybe even some, elder abuse happening or suspected, you may even want to get the police involved, because they generally are able to get direct access to the will maker and conduct a wellness check, which, then you have a police report available, and there might be some gold nuggets in there that we can use down the line. But, if you're not able to get access, get someone who can. And that's the point. Don't give up. It's such a trying, I've often seen it, even the people who are witnessing it get worn down and hopeless in the situation. And you need to persevere, and you need to keep trying to, like Helen says, involve yourself, because the moment you stop, they really do have free reign.
Thanks, Nicole. Prevention is the best medicine. There is some assistance available through the public guardian and trustee, some other organizations, but those may be good for documenting a paper trail, not always good to get a remedy or reverse a coerced estate plan. So sometimes, despite the party's best efforts, these things do percolate into a court dispute, a challenge. In such a circumstance, courts can exercise all kinds of powers and grant all kinds of remedies. But as we've discussed, these cases are anything but straightforward. So, Helen, I just want you to speak on that point a bit. Talk about how challenging it can be to pursue a remedy in the court, what remedies you've pursued, and what can our audience learn from those experiences?
Well, Desmond, if the situation has progressed to the point where the vulnerable person has made a plan that you're trying to challenge on the basis that this isn't what you think your parent wanted to do or the vulnerable person wanted to do, and you're stuck into the legal system, then litigation is a process that's set with a whole number of rules. First of all, you need to fit your case and the facts of the case so that the court can rule that the facts of your case gives rise to a legal ground that the courts recognize as something where they can give a remedy. And of course, undue influence is one of those. But what people think undue influence is, and what the court says undue influence must be proved for a legal remedy, we've talked about that. There can be a big divergence in that. If the only ground upon which you can frame your case is undue influence, because there's no other legal ground of claim that you can make, then I feel sorry for you, because that's going to be a very difficult claim to make out. Often, however, the facts that surround undue influence also give rise to other causes of action. So often you can argue lack of capacity, and that is where the elderly person may have loss of mental acuity, or maybe this was being done at a time, let's say they were having cancer treatments and they were really physically worn down, physically and mentally from it, or if they're just not as sharp as they were, but they may not have been diagnosed with a level of dementia that precludes them from being able to live alone and manage and pay their bills, everything's done online, etc., and you don't know, because dementia isn't an on-off switch. It's a problem these days because of the length of time that so many of us enjoy on the earth, but not always with all of our full faculties. But you could allege lack of capacity. There also is a claim called lack of knowledge and approval, which works well with undue influence. It's that the individual did what they did, but they didn't fully appreciate the legal consequences and significance of that, even though they weren't entirely without capacity and they weren't entirely without some level of free will. And so when the situation arises, I would just suggest you go to an estate litigator, somebody who really knows this area of litigation and can put together all of the claims that could arise on the facts that you give them. And the more facts that you've given them because of the notes that you've taken, as Nicole has counseled, then the more likely you are to be able to get the court to step in somewhere. I have had many cases where the court wasn't so prepared to go and say that Helen unduly influenced the individual because of the sort of a little bit of a taint or a stench of fraud there, but prepared to set the plan aside on another ground. And the taint of the undue influence, I think, really made a difference to finding that the person lacked capacity, for example, from a legal point of view. So my point is, try not to get to the point where you're in court, but most times that's when it's discovered. In fact, actually, quite often it's discovered then. And then go and get advice from someone who really appreciates the nuances in this area.
Thanks, Helen. And before we leave our imaginary litigation here, you've brought up a lot of great causes of action we can bundle together with the assertion of undue influence to try to get help from the court in dealing with some untoward conduct that's gone on. Nicole, what kind of remedies can we expect the court to be able to give us? What kind of help can we expect they're able to dole out in circumstances like this when someone brings a claim of undue influence?
So as Helen has said, and I'll just summarize it very briefly, remedies are really fact-specific, and it's going to depend on the nature of the influence and the timing of the transaction and the vulnerability of the donor. It can be something as, if you're still early on and you've realized that this person has no capacity, it's a guardianship or committeeship application, or it's as far down the spectrum as having to set aside the document or power of attorney that's been put in place. So it really depends on the circumstances. And we love alternative claims because, as Helen said, you often don't just go to court and plead undue influence because there's so many different factors to consider, that you'll have your alternative claims and hope that something, even if you fall short of undue influence, you're able to challenge the document on another basis. The courts ultimately are going to aim to honor and restore that individual's true intentions. So that's the ultimate goal. It's not really about punishing the wrongdoing, though punitive claims can arise. But really, it's about honoring the true intention of that individual.
Thanks, Nicole. And I'm mindful of the time here. I know we were going to speak to a couple of brief takeaways, but I think as the presentation's unfolded, we've kind of hit the highlights over and over again, what you should do, document everything, get involved early, stay involved, get legal advice. And we're getting a lot of questions, and we've got a lot of questions in the past about something I think no one's going to be surprised about in today's current climate, and that's about AI. What's the impact of AI? How's it augmenting frauds? Are we concerned that vulnerable people are going to be exploited more in this new age of AI?
Yeah, it's not are we going to be, we are concerned. It's happening for sure. We are seeing so many calls coming through of my mom is withdrawing money because this person she's talking to needs money, and they've developed this relationship. And the problem is that AI has become so good, so convincing. You've got voice cloning, deep fakes. They can make a person sound like that person's child or grandchild. You've got the emails, the fake emails, it's no longer the Prince of Nigeria who emails you with really bad English. It's become so convincing. In fact, this was one of the questions we got before we put the webinar together. And when I Googled the risks of AI with the elderly, there's actually programs now of creating AI companions for elders. There's a whole project happening at UBC where they've got this robot and people speak to it, and they're really buying into this because it's so effective in building trust and creating a relationship. There's a case in the US right now where I think they're suing the Google AI chatbot thing because it convinced a child to commit suicide. So just think about how convincing an AI companion can be. And you are sitting with elders who are often isolated because their friends have passed on, and perhaps they don't have any children, and all they have is the internet at their disposal, who is keeping them company. And we are seeing this so much. And really what's important is education. Educate your clients about the risks. Educate your clients about the technological advances that are happening and how good it's become and how convincing it can be. Catfishing. My assistant was telling me about a friend's neighbor who she's completely in love with someone from New York, Keanu Reeves, who she's been talking to for months and months now. In fact, has been sending him money and will be buying a ticket to New York and go. She's going to be living with him. She's going to give up her rental here, which I don't know where she's going to find a place in Vancouver to come back to that she can afford but this is what's happening to people. And the person has no family, no friends. She's alone and she's in for a huge surprise. And, we as professionals, as advisors, we really need to, as family members to our loved ones, we have to keep educating and really let them know the risks of technology and really amp up the supervision, amp up the education, and know who has access to your loved one or your client. Yeah, that's it. It's going to become a really, really big problem. It already is.
It certainly is an interesting area. We use these tools so often for good things, but it's just something to be aware of that they can be tools for nefarious purposes as well. I'm just looking now to the questions tab. Helen, I want to raise this one with you. I think it's been described as a Globe and Mail article addressing elder capacity. There was a document executed called a power of authority, utilized before the actual power of attorney for property decisions would be exercised. I think it was exercised due to incapacity on the part of the elder parent. Are you familiar with this concept of power of authority, something that goes before a power of attorney, or do you think these things are one and the same?
I know nowhere in law where there is a document called a power of authority or something that is sort of the prequel to a power of attorney. In British Columbia, we have a type of representation agreement, which I could appoint you, Desmond, to help me to do certain basic financial matters like pay my bills, but standard matters, but not to represent me in a fulsome way, like to manage all my money and to take steps to do any estate planning for me. And that document it exists, but it's not in very popular use, because I think financial institutions, they're very good now with both money laundering and safeguarding of scams. They don't accept anything that doesn't appear to be, a regular document that they have seen. Maybe undue influencers are walking around creating these documents to give to third parties who are not as sophisticated in order to be able to use those. So I'm not sure if I went and brought that power or document of authority to Nicole's garage and said, oh, I'm supposed to pick up Nicole's car, they might release it to me. And next thing you know, I've gone for a joyride in it and kept it. So there will be more and more, I think, attempts to defraud people. I mean, the safeguards for a power of attorney probably will be increased in the future, but it's very easy to make, a fake document. You can forge a lawyer's signature, put in a stamp. If a person really wants to commit fraud, they can do so. So people who receive these documents should just go and get some advice. Is this something I should do anything, with, in terms of, do I consider it has any authority? Do I take it to a lawyer? Do I go to the vulnerable person? I would always question something like that.
Thank you very much, Helen, and thank you to Nicole. I'm mindful of the time we're at. It appears we're at the end of our time for today, so thank you everyone for joining us. You'll see on the screen now, there is a QR code and a link for you to access your CPD credits for Ontario, Quebec, and British Columbia. Those links will be circulated after the seminar as well in the chat of this webinar series. If you don't get a chance to claim that certificate right now, we can send those later on this week as well. I believe the marketing department will be doing that. And so looking ahead, the third and final webinar in this 2025 estate litigation seminar series, it'll be held on November 20th, topic being Beyond the Will, Managing Dependent Claims, Modern Family Dynamics, and Unexpected Heirs. Make sure you tune in for that. And finally, if you still have any questions or you'd like to discuss any of the topics covered here today any further, please feel free to reach out to any of us directly. We're always happy to privately discuss issues where needed, loop in colleagues across Canada to navigate provincial nuances, including in Quebec in the civil law context. So thanks again, everybody, for coming, and have a great afternoon.